Hello, everybody.
$24,200,94508 Sunny Meadows Mobile Home Park LLC v. Terry Galloway, Barbara Melvin, Amanda Phillips, Elijah Melvin.
That matter's ready.
Okay.
So if the court oh, go ahead.
Nope, go ahead.
All right. So in this case, this has already been set over, and then due to the outage, set over again. This was a case that was filed September 18th, had a preliminary hearing in October, and now here we are in mid to late November. So essentially this has been pending for 2 months. Filed the declaration of my client in reply to Mr. Kiernan's materials that clearly outlines essentially that the tenant has paid nothing since July, that CAP has made some payments, but CAP doesn't pay the entire rent. It's a sort of, they start with 100% and then they slowly pay less and less each month, and CAP doesn't pay utilities. So the tenant has paid none of the utilities and none of the rent that CAP didn't pay. This has left a total owing of $1,859.35. As of this morning, what is in the clerk's registry as of 8:45 is $800. That is not the amount that is owed. This is the second filing regarding Mr. Galloway in about 3-4 months. There was a prior filing, which we specifically referenced, where CAP came in June and sort of paid off the amount, and then we sort of got immediately back into the same position with the tenant not paying. The question would be, can the court set a payment plan? No, the court cannot set a payment plan. Under RCW 5918-410, if the tenant has been issued 3 or more 14-day notices within the last 12 months, the court does not have the authority to allow for a payment plan. Specifically, at that point, if the tenant has not paid in full, at that point, the landlord's entitled to their rent. And in this case, this is why, is that plaintiffs can't be in a position where essentially you make them permanent creditors or people who have to permanently extend credit and sort of just not get paid and accept it, go to court, get paid at the last minute, that it never pays for the legal fees, and it's a never-ending cycle. My client specifically testifies that that's a hardship. It causes difficulties with the business, that it's challenging, and that this is a tenant who just isn't paying anything and hasn't for an extended period of time. He hasn't paid, he hasn't, and the court specifically said, I expect you to put money in that you think you owe. We've proved up exactly what he owes. There's nothing that contests that. We are asking at this point that the court issue the writ.
Mr. Kiernan, go ahead.
Your Honor, I'd ask for a 2-week set over so my client can make the payments. We just got pretty much an idea of what my client owes yesterday when we got that declaration. The amounts in the notice were completely false. They said that he owed complete or all the amounts of rent. My client was disputing that because he was saying CAP was paying the rent, so he never knew the exact amount to pay. According to our calculations, he owed about $743.75 in actual rent. And he paid $800 into the registry, which has covered rent through November. We just did not know the utilities balance, Your Honor. There's no reason at this point to dispute the utilities balance, but we just got it yesterday, so I need to talk it over with my client and give him a chance to be able to make that payment. So we're just asking for 2 weeks so my client can make the payment, because again, we just found out pretty much what the value that he owes is. He made a good faith effort to pay the entire rental amount. Now that we know the amount that he needs to pay, my client has the ability to make that payment, and he's going to try and make it. I was not able to communicate with my client in the couple hours after I was served to get him to pay into the court registry because he is working a full-time job now. I think if we can have 2 weeks, my client will be able to pay. Again, we're not necessarily disputing the amount owed here. We're just disputing that my client did not know what the amount was owed until yesterday. So I would ask for a 2-week continuance with the understanding that if my client doesn't make a payment by the time that this 2 weeks has happened, then the writ will likely issue. I don't necessarily disagree with the fact that a payment plan might not be able to be issued here, given the things. But my big problem is we just did not know the number until today. The number's about $1,000. My client is working full time. We're fully expecting that he's going to be able to make that payment now that he knows what he needs to pay, Your Honor.
When did he make the $800 payment in the registry?
On the 18th. So he
okay.
just made it this week.
I thought we made it a few weeks. Well, I think it might have just been entered with the information. We deposited it, I believe, the first day of the court outage, Your Honor. Let me see if I can find a receipt in my file that says that.
When we called and asked, that's what the clerk said. It was on the 18th.
Let me just see. I'll check with the clerk. Does your file say when the deposit was made and perhaps it was affected by the outage? I don't know.
I believe we had to put all payments into Odyssey. I don't know that we had put a comment on when we received it.
Oh, just when it was credited.
Yeah. We couldn't credit them after Odyssey.
Response, Your Honor, when you're ready.
Yes, please, Ms. Baldwin, go ahead.
So this argument is a farce. So counsel says he didn't know what to pay. Absolutely not. Their own materials belie the argument. They have filed a letter from CAP that's dated June 24th that says CAP is going to pay these amounts. This is his own declaration that he submitted to the court a month ago. So he then pays nothing, even by his own estimations. On best case scenario, comes to court, case filed September, he pays nothing, knows what he owes. October, pays nothing. Doesn't pay until November 1st, and we've already had that initial hearing. And we have this letter that he himself submitted that goes through and says, CAP's going to pay this, you owe this percentage, CAP's going to pay this, you owe this percentage. So he absolutely knew. He can't then come to court and say, I didn't know what to pay. That does not work. You can't have it both ways. The 14-day notices that were issued, he does owe. CAP does not owe his rent. CAP is an outside agency that is stepping in and paying on behalf of him. But CAP is not the responsible party. They can choose to not pay if they want to. That's not true for the defendant here. So this, he doesn't know. Absolutely. He knew, he's known the whole time. And counsel's argument for a 2-week continuance, that's a payment plan. That's just a payment plan in a different name. Well, won't you give me a 2-week payment plan? That's what this is. I want a 2-week payment plan. His client hasn't even paid half of the obligation that's currently owed. And in 2 more weeks, there's another rental obligation that comes due. My clients at this point, there's a long track record at this point. We've got the prior case that was filed, and my client saying he has paid $0, 0 utilities, 0 rent since July, since the last time CAP bailed him out. My client should not be essentially someone who has to just continually wait. This is what this law is built around. It's built around the fact that at some point, the plaintiffs in these matters have the right to get their property back. They don't have to constantly wait. And when somebody has repeatedly not paid and they've issued 14-day notice after 14-day notice after 14-day notice, the court needs to just issue the writ. That at some point, plaintiffs' rights need to be held and need to be given equal weight to the defendants. There's supposed to be equity. My client has the equity here, has the argument here. The defense is just, won't you give us more time? Won't you make a payment plan and just not call it that? That's not lawful. It's not appropriate. The court should issue the writ.
And Your Honor, just to make a response to that, I would like to just note that my client didn't know what to pay. This notice was patently false and incorrect. If you look at the notice, it says that my client owed rent for July. We provided something that shows that CAP paid 100% of the money in July. It said the client owed 100% of rent for August. We've showed a temp that said CAP paid 100% of the rent in August. The notice that my client received was just misleading, false, and incorrect accounting. So my client did not know what he owed until quite frankly, yesterday. He was trying to conflate the values that Cap was paying with he was paying. Certainly the amount on the 14-day notice were just incorrect, Your Honor. So there really wasn't a way that my client could have possibly known what to pay, quite frankly, until Thursday, because he didn't have any utility information, Your Honor.
Ms. Baldwin.
Yeah. So my client is, like most landlords, does not accept partial payments, and that's what it was. So Cap would send a check, but not pay the utilities. And the defendant wouldn't pay the utilities. So my client said, I can't accept a partial payment because you're not paying the utilities. And said, no, sorry, Cap, like I appreciate you trying to make a payment, but I'm not going to accept a partial payment. So they held that in abeyance. So my client hasn't accepted partial payments. And so the full amounts were due and owing. Now, at this point, we're giving him credit and assuming that Cap is still going to uphold their agreement. But my client has held those because they are all partial payments. So he did owe the full amount. And again, and Cap's letter that defendant himself submits is very clear that he owes the utilities. And he just sort of wants to ignore that fact. And again, ignore the fact that he has this letter. So, and here we are, we've given him full credit, even though my client hasn't cashed the checks for from Cap because they've all been partial payments. Even so, we've given him credit for everything that Cap has stated they're going to pay. We're still $1,800 under. He hasn't paid. There's no pledge for that amount. And we're still in a position where we're still in that position, is that the request is, won't you just kick it over and make a payment plan by another name?
Yeah, go ahead.
We're not asking for a payment plan. We're saying if we do not make the payment in 2 weeks, we are going, I mean, we understand that a payment plan cannot be there. I did not have a chance to talk with my client about how much was owed. I did not have a number, Your Honor, until yesterday. Now that I have a number, I can bring that to my client and say, can you pay this number? I did not have that ability till yesterday, Your Honor.
The court told him specifically to put into trust what he thought he owed.
Yep.
He didn't do that.
Yep. So here's when I do the calculations, the amount in the complaint is exactly the base rent plus utilities. So the amounts in the complaint are aligned correctly with what is now being alleged. So I don't think this is an issue where the tenant wasn't given notice of what was behind. He easily could extrapolate, for instance, July 861.93. If he knew Cap made the $650 payment, the $211.93 is the utility amount. And the notice is very clear that this is monthly rent with utilities. So I do think that he was on notice what he owed. I think the court has given the tenant or tenants several opportunities to get up to speed. We first were here on October 18th. We continued the matter to October 25th. At October 25th, I did order the respondent to deposit funds into the court registry, the amount that he agreed that he owed. But again, I think the $800 is far lower, just looking at the original complaint, than what he should have known that he owed. So and again, I'll just be clear, then we were here November 15th, just a week ago, and set this over 1 week to, again, give him more time. So we're over a month since his first appearance. We're in no better position really financially than we were when he first appeared. So I think given his history of 14-day notices, me doing a set over for 2 weeks is essentially a payment plan for him. And I don't—
Your Honor.
Hold on.
Oh, sorry.
So I don't think that's appropriate. I am going to sign the order for writ. Go ahead, Mr. Kiernan.
Your Honor, could I ask that we stay the writ for 2 weeks just so I could ask the judge, or I could give my client an opportunity to make a payment now that we have the number? Because again, I did not have a number I could bring to my client until yesterday. So I think this strikes a balance where if my client is able to make that payment, he still has the rights to do that. Again, he's working full time. I have not been able to talk to him. He's, doing roofing. He's back to work now. It's been tricky for me to communicate with him. This strikes a balance. The landlord will either get their money or my client will get the writ signed, Your Honor.
Respectfully, it doesn't strike a balance, and it's still just a payment plan. So counsel is saying, won't you just give me a payment plan after the fact? So it's the same issue. And for my client does not want to rent to this tenant. They have never paid rent in more than a year. It's always been capped and someone bailing him out. And at some point, my client doesn't want to be in the position where every 3 to 6 months they have to come to court, and that's the only way they get paid. And once you add in my fees, it's not the profit line doesn't make any sense because they don't get paid back any attorney fees. So I'm asking the court not to do that.
So what I'm going to do is just sign the order for writ as presented. I think given his history of March, August, September, 14-day notices, I do think it's appropriate to issue the order for writ. I think that allowing additional time, I think probably puts the landlord back in the position they've already been in several times this year. I obviously understand that this allows him a few days next week to make that payment if he has it. So I am going to go ahead and hand that up to the clerk.
And then there is $800 sitting in the clerk's registry. I would ask the court just issue a bench order that awards that to my client. By placing it in there, he admitted that he owed it. And that's reasonable that I don't want to just sit there until the clerk notifies us one way or the other. So I'd ask that just be issued to my office.
Mr. Kiernan, a position on
I
that?
would not agree to that at this point, Your Honor, because those might be moving expenses for my client. I just don't want to, my client disputes it. I'd like a chance to speak with him.
But he doesn't dispute it. He agreed that he owed it. That's why I put it there. So that I'd ask that the court order it be held.
Yeah, I'll have it remain held. I'll set this on for review December 6th. Mr. Kiernan, if you want to provide any affidavits or briefing, I'm certainly happy to accept this. I did previously look at that issue. I think this was a personal service case. So, but I'll give you 2 weeks to December 6th if you want to brief that for the court.
Okay, and that'll make it easier so that you can have just a running total what my client owes. So that way, if he is able to pay the extra $1,000, we can just stay this rate a little bit easier.
Okay, thank you, Mr. Kiernan. So first, Sunny Meadows Mobile Home Park v. Terry Galloway, Barbara and Elijah Melvin and Amanda Phillips.
So we have a procedural issue before we commence. Here's my issue. This is a case where a writ was issued. Subsequent to the writ, Mr. Kiernan filed a motion for stay, does not serve that on me, gets the stay, serves the stay along with an email stating, here are all these things I'm serving on you, none of which are attached. Only attaches the order for stay. This is provided yesterday afternoon. I reached out to their office this morning. Their office provides midway through the docket, oh, well, here's some of the things that we said were attached but weren't, acknowledging they didn't actually serve them. And what's then subsequently provided still does not include the motion for the stay. So as we stand here, I still have not been served with the motion for stay, which is a significant problem when we're going to go to the court ex parte and ask for relief, and there's counsel involved to not provide notice to counsel. If you're going to file a motion ex parte, so be it, you have to provide service. And to not have provided service by the time docket starts, frankly, it's just not excusable. Because there's no way for me to proceed forward. I haven't seen it. Can't tell you what's in it. So there's no way for me to defend my client. So what I'm asking to do is to set the matter over 1 week. Mr. Kiernan's office needs to serve the motion for stay on my office. And then I'm also asking for terms, and those terms should be paid. We're only here based on that motion, the ex parte motion for stay. There just isn't any reason why it wasn't served on my office.
I would just respond that I filed the stay under RCW 5918-410-4, which allows me to file it ex parte with an email to her, which states that. But this is kind of irrelevant, quite frankly, the motion, Your Honor. The only thing that is really relevant here is 410-2, which doesn't require me to do a motion. My client, within 5 court days of of the entry of the judgment. So within 5 court days of when he was evicted, put all of the money into the court registry, Your Honor. If you look at 410-2, it says before entry of the judgment or until 5 days after the court has
Mr.
expired.
Kiernan, when did you serve these on me?
It doesn't matter.
It
There's
does.
no
Hold
motion.
on 1 second. So let me just back up here. I don't have, so hold on, I'll let you both speak, I promise. But I'll tell you what I do and what I don't have. I don't have, and I assume it was done yesterday, so it wouldn't be in the system yet, but I don't have the ex parte stay request. I don't have the order staying. What I did receive after docket started was a motion to reinstate tenancy, indicating that the $3,000, which allegedly exceeds the rent owed, court costs, and late fee. I have that motion in front of me, and I'll be honest, I'm reading it as you're speaking, Mr. Kiernan. Again, I didn't have this before docket. I don't know if Ms. Baldwin has this.
And can I just briefly explain the posture of this, because it is a little bit confusing, Your Honor.
Okay.
We have within 5 days from when the court issues the judgment to put all the money into the court registry. On Tuesday, we did this with all the money, and I told Miss Baldwin, and we provided her with receipts that showed that we paid all of this money into the court registry, Your Honor. At that point, I thought the landlord would take it on themselves to reinstate the tenancy, because if you look at the language of 410-2, there's no motion. It just says as soon as that money is in the court registry, the tenancy is reinstated. It's mandatory. There's no judgment on your end. There's no, I need to file a motion. It just says before entry of the judgment may pay into the court the amount of rent due, any court costs incurred at the time of payments and late fees, in which the judgment entered shall be satisfied and the tenant restored to his or her tenancy. So once we put that money into the court registry, the tenancy was restored. We don't need to do a motion. We don't need to do anything. And it's undisputed that that money is in the court registry, Your Honor. Now, this writ was executed on Friday or on Thursday. My client is currently not able to go into his home, which he has been reinstated in, Your Honor. There is no dispute that this money, $3,000, was into the court registry. Now, we might be able to say, quite frankly, it's really a question of how much money my client's getting back at this point. But it's undisputed that my client put more than enough money into the court registry. There doesn't need to be a motion. There doesn't need to be anything. It is an execution of him putting the money into the registry, Your Honor. And opposing party had full knowledge that this money was in the registry, Your Honor. I sent them an email which stated that. So I'd ask you to sign an order today which allows my client to return to his home.
Ms. Baldwin, go ahead.
Boy, howdy, that's a lot. Mr. Kieran says it's undisputed. Boy, wouldn't I love to serve somebody as docket is proceeding and then say, with no ability for the other side to respond, well, it's undisputed. It's undisputed because my client hadn't even had a chance to look at these documents because docket is currently going. They don't even deny that they didn't serve me with anything other than the order late yesterday, and then served me with the other documents as docket was proceeding today, and only at my prompting that their certificate of service was incorrect. So counsel stating there's no dispute because I haven't had an opportunity to. And that's the whole point. It is wildly law by ambush, and so much so that you're doing it on docket as docket is proceeding. I'd love to serve Mr. Kiernan with documents as docket is proceeding and then just say, well, it's undisputed. His client doesn't dispute that he owes rent. Mr. Kiernan's going to demand 2 weeks. So it's offensive. It's offensive that Mr. Kiernan thinks it's appropriate to not serve me and that's fine. It's not fine under the law. The argument that, it's just automatically instated. No, there is a court order to execute and to remove them from the property. Only if they can show and have a hearing that says, we've paid and there's a dispute. And Mr. Kiernan's wrong. It says they have to pay the full amount in rent that is due and owing at the time, attorney fees. They also have to pay certain amounts just to redeem the tenancy. There's sort of like a fine that's built into the statute. Mr. Kiernan sort of wants to sweep that all under the rug and ignore that there's all these additional things that are part of getting a tenancy reinstated. So where we are now is Mr. Kiernan's clients at the 11th hour got a stay. So they haven't been reinstated. There's no order that reinstates them. What they have is a stay on the execution of a judgment. So that's where we are procedurally. Where we need to go is that Mr. Kiernan needs to serve any documents he's filed with the court on me. And we're still in a position where he has not done so. And then have an actual opportunity to have a hearing where both sides can be heard. This is not a one-sided deal where only the tenants get to file things and be heard. This is an adversarial process where both sides get to be heard and both sides get to have their evidence before the court. And Mr. Kiernan's arguments to the contrary are just simply contrary to justice and contrary to the law. So in this case, my requests for terms are appropriate given the lack of service. And given the fact that I've had to sit through this docket for this hearing due to the lack of service, I'm asking to set over 1 week, require them to serve anything that they haven't at this point served on me, which includes at a minimum their motion for stay. And then I can respond appropriately and we can have an actual hearing next week.
And Your Honor, I would just like to note under RCW 410 or 48, RCW 5918-410-4, I'm able to file these ex parte notices with emailing Servinger, letting her know that I did that. I'd like you to note that in nowhere in any of the defendants or the plaintiff's argument did they state that I did not let them know within 3 court days or within 5 court days that all of the money was in the registry, Your Honor. We sent them a receipt from the court registry. Quite frankly, normally when this happens, Your Honor, the defendants the plaintiffs take it on themselves to stay the order because they know that they have all the money. They're trying to muck it up by saying there's court fees and all of these other things. No court fee or no attorney's fees were awarded. We paid in excess of the amount by quite a significant amount. When we were here 2 weeks ago, Your Honor, they were saying that my client owed $1,300. There was already $800 in the court registry. My client has since deposited another $2,200 into the court registry. There's really no way that we can make this, that we can figure this out that doesn't have my client covering all the bases. So once they covered all the bases, if you look at this, there's nothing mandatory. I mean, this is all, it says once if you read the entire provision on number 2, once my client puts that money into the court registry, they have reinstated the tenancy, Your Honor. So I would like my client to be able to go back into his home.
So, but here's my question, because what triggers the restoration of tenancy is pay into the court or the landlord the amount of rent due, any court costs incurred at time of payment, late fees if such fees are due under the lease and do not exceed $75 in total, and attorney fees if awarded. So what is that amount? I guess that's what I'm missing. I have heard, Mr. Kiernan, you say, of course, it's more than what's owed, but I don't have that amount.
So they stated as of last time we were in court, it was $1,300, Your Honor. My client,
and contrary to the pleadings,
or $1,600, I believe, and that was in the declaration that they filed. My client had $800 in the court registry, and then so my client technically only had to file, a smaller amount than what they did file. December's rent has passed, so even if we include December's rent payment of $800, he's still well in excess of the amount that he needed to pay, Your Honor.
So what is the amount he needed to pay?
I can do some. I just want to get you the correct numbers.
Should have been done
Ms.
earlier.
Baldwin, what's your client's position about what's owed?
So it puts me again in a almost impossible position because Mr. Kiernan plays this game of I'll serve you as docket is going, respond on the fly, and then I win. And that's why it's not fair. This is law by ambush. And that's why this is not a lawful process to do it this way, for Mr. Kiernan to sort of play this game this way. So so I can tell the court that the last pleadings showed only through November that he owed 1,800, and I'll just say 60. It was 59 and change. Plus he owes December's rent, plus he owes court costs, plus he owes the statutory amount for redeeming the tenancy. And I would argue that the court never addressed attorney fees. So the court also needs to address attorney fees, which at this point are substantial. We've had multiple hearings on this case. That does take us to a place. And again, the court has to recall, this is a case where the tenant has not paid for essentially a year. This is a tenant where previously redeemed the tenancy in the middle of the year. So there's a tacking under the statute that every time you redeem, that you have to pay more essentially each time. So again, these are things that I'm going to have to sit and do the math to see whether or not this actually gets us to a place of whether he's put enough, because I think it's a legitimate question on whether or not he's put enough. It's odd to me that Mr. Kiernan is saying my client can return to the home. They got their stay. They got their stay. So his client isn't out of the home. They got their stay. So, and I'm not saying that that stay is not enforced for the following week. At this point, the stay is in place, and I haven't been served documents for me to be able to address it.
What is
So,
the
I
emergency?
guess my major concern was
hold
the
on one
client
sec.
being allowed in the house. So
Just-
if there's no dispute about that, I'm okay with as much time as necessary, quite frankly.
Because again, it's not in my system, probably because it happened yesterday. What's the wording of the terms of the emergency stay? What is it?
I think it's just said it's just stayed.
Yeah, it's just the state of the execution of the writ, which technically the writ's already been executed, Your Honor.
But does it say until the next hearing? I guess my question is whether that emergency stay expires today.
Well, I guess then so that's a factual question. Mr. Kiernan, was this executed prior to the stay?
It
because-
was executed prior to the stay, but I'm saying that he reinstated prior to that.
So that's a really significant financial question or factual question, because the statute says that they can be reinstated and redeem the tenancy, but only until the execution. So frankly, the type, like I only have a conformed copy. I don't have like the clocked copy on when this was clocked. And frankly, the clock matters on this one. Because if the sheriff's office removed them from the property prior to the stay, then that's probably dispositive in this case, because they
and our issue would be that they reinstated prior to the execution because they put the money into the court registry prior to the execution, Your Honor. And just to let you know, so my numbers are total, including December rent. He owes $2,842, and he's put $3,000 into the court registry. And I would just like to note, at the time that my client knew what he needed to do to redeem, attorney's fees had not been awarded, Your Honor.
So
We understand. So here's what I'm going to do. I think that this strikes a balance. I think this is a very unique case procedurally, factually. There are a lot of moving parts here. And again, I wish I had the stay language in front of me. But what I'm going to do in both law and equity that I believe is fair, I'm going to sign a bench order that continues the motion to restore tenancy, or to reinstate, motion to reinstate tenancy under subsection 2 to next Friday, December 13th at 9 a.m. I am going to include in my bench order that given a threshold showing of payment into the court registry, that might cover court costs or all of the past due rent, court costs, et cetera. And again, might, because we haven't held a hearing on it, that the starting right now at 10 a.m. on December 6th, that the tenants are to be allowed back into possession of the rental property through the date of our next hearing, when a final decision will be made.
Thank you. That works for me, Your Honor.
Yeah, I'm just trying to think through the problems.
Yeah.
Because they've already been evicted from the sheriff.
Mm-hmm.
My concern. I mean,
I know.
effectively, if the court
Mhm.
if the court sides with me, it doubles my client's costs on the essentially on the sheriff's side, because then they won't leave voluntarily. We'll have to have the sheriff come out again, and have to re-execute essentially a new writ.
And
Yeah.
and I understand that. I think the issue that I'm having, and again, I don't have it in front of me, is that my understanding is that a motion to stay execution of the writ was filed, and correct me if I'm wrong, but I think the ex parte motion for stay was filed before there was execution of the writ. It wasn't signed until after, but it likely does stay execution of the writ that may or may not have applied to retroactively. I don't know. I don't know what the judge signed. I have no way to know. But I think what I'm signing today in under the RCW is to continue the motion to reinstate tenancy so that we can do the fact finding to see if these things have been paid. But I think in equity, given everything I have heard today and my understanding of the timing of events, I think it is equitable for the tenants to be allowed back into the property for this week pending that hearing. It does appear, just again, Ms. Baldwin has not had a chance to run the numbers, and I completely understand that argument. Just based on the numbers we have here today, there's been at least a threshold showing that he has paid amounts into the court registry that might cover those full costs. So that is why I'm granting the week. We'll resume next Friday with whether this truly is a reinstatement of tenancy or not.
Okay. very
Now,
good.
I understand there's some weird factual things. How do you unring a bell that's been rung? I know that's come up before, but my hope is with my bench order that at least for the next week, they are allowed back into possession of the property.
Thank you, Your Honor.
I'd ask that the court previously ordered this, and it should continue that Mr. Galloway and whoever has paid into the court registry cannot remove funds from the registry, that those funds are held until court order.
Yeah, I think that's reasonable. If he did
Okay.
remove them, I think he would be evicted because they wouldn't be paid to the landlord.
Well,
No.
it's gamesmanship that he could be then removed and then play the game of, but now I'll pull my funds back. So
Okay. I will include that. The
My
tenant.
client wants to remain in the home, so part of that is keeping that payment, Your Honor.
Okay, so pending final resolution, tenant is not to remove funds previously deposited from the court registry. Okay. Okay, thank you both. We'll see you back next Friday.
I love you guys all so much. You've been amazing. Be safe, be well, sleep sweet, and much love.